Welcome, good afternoon, and welcome again to today's virtual CLE entitled Technology, Surveillance, and Device Tracking in the 2020s, Frontier Issues in Fourth Amendment Law, presented by Albany Law School's online programming. I'm Tom Rosenberger, Assistant Dean for Online Programs here at Albany Law, where we're celebrating 175 years of transforming legal education. This program is the fourth of Albany Law's ongoing CLE series on cybersecurity, privacy, data protection, and while not officially in the title, a lot on AI as well, exploring the now and next of these critically important and rapidly evolving issues. This series underscores Albany Law's commitment to building a global online community that offers innovative and accessible programming for lawyers and other professionals whose work puts them at the intersection of technology, law, and business. We're offering a slate of programs on topics ranging from AI risk assessment, regulation, boardroom readiness, and Fourth Amendment concerns in relation to cybersecurity, privacy, and data protection. Each program includes expert speakers who are practitioner faculty and other faculty in our online program and certificate, degree program and certificate in cybersecurity and data privacy. Programs are that you attend live will satisfy New York State Bar Association's CLE, cybersecurity CLE, requirement. And if interested in any of the prior events you see there on your screen, we invite you to return to our website where you'll find the recordings open and available. I'll provide that link momentarily. Just a few additional notes before we get started. CLE credit is only available to those who are in real-time attendance today and capture the code word, which will be announced at some point during the program. Attendees seeking CLE will need to return within 24 hours the fillable PDF affidavit that my colleague Lisa Rivage provided to you via email, I believe, on Monday. We also ask that you take a moment to complete the evaluation form, which helps us identify future programming. Today's agenda is quite full. However, the speakers welcome questions via the Q&A panel throughout, and we'll address them as they're able or near the end of the hour together. Without further ado, it's my privilege to introduce today's speakers. Matthew Tokson is a professor of law at the University of Utah S.J. Quinney College of Law and a leading expert in Fourth Amendment law. His research focuses on the Fourth Amendment's application to new technologies and social contexts, and he has written about issues in privacy, artificial intelligence, judicial decision-making, and criminal punishment. Matthew served as a law clerk to the Honorable Ruth Bader Ginsburg and to the Honorable David H. Souter of the U.S. Supreme Court, and has served as a senior litigation associate for a Washington firm. Joel Schwarz is an adjunct professor teaching in Albany Law's online graduate program in cybersecurity and data privacy. When he is not teaching, he is a consultant and attorney specializing in privacy, technology, cybersecurity, compliance, and oversight, with a specialty in HIPAA compliance, as well as cybercrime response and cyber intelligence. Joel is a former privacy/cyber prosecutor at both the state and federal levels, a former intelligence community's privacy officer, and has worked in the private sector as well. Finally, Joel is a co-founder and board member of the Student Data Privacy Project, a foundation focused on working with parents and school districts to protect student data privacy and hold ed tech companies accountable for safeguarding student data. Both bios here have been truncated. Both speakers have very impressive resumes, and I invite you to read them in full in the PDF materials that were provided to you by Lisa Rivage. So with that, I'm going to stop sharing my screen. I'm going to invite the speakers to share the content slides and to please take it away.
Thank you, Tom. I'm just going to set up the slides here. All right, so hopefully everyone can see that. It's a pleasure to be here with you via Zoom today. And we're going to do sort of two main things here today. We're going to do a quick overview of modern Fourth Amendment law, and then we're going to talk about how to apply modern Fourth Amendment law to novel issues using some recent cases as examples. Here we I want to start by telling you about a frontier Fourth Amendment issue. Here's the case, right? It starts with a house fire in Middletown, Ohio. The house was owned by a man named Ross Compton, age 58. Compton had some health problems, and he had a pacemaker installed in his chest. One night in 2016, Compton's house caught on fire. He escaped the house and called 911 and reported the fire. It took the firefighters about 30 minutes to get it under control, right? He told investigators that he woke up, saw the fire, packed his belongings in a suitcase, smashed his bedroom window, tossed his suitcase out, and climbed down to safety. Police were skeptical about the story, which didn't really match with the physical evidence at the scene, but they couldn't prove that he was lying. So they got a search warrant for his pacemaker device. The device stored information about Compton's heart rate, pacer demands, and cardiac rhythms. And it turns out that the pacemaker information didn't match Compton's story. Right? The data was inconsistent with the story that Compton had packed a bunch of heavy items, smashed a window, and then climbed outside. Something like that would have affected his heart rate. But Compton's heart rate was normal pretty much the whole night. He was arrested and charged with arson and insurance fraud. Increasingly, pacemakers and other medical devices gather and store information about their users. Many of them are connected to the internet, allowing third-party medical service providers to analyze the data and to monitor patients. Here's a photo of an internet-connected pacemaker here. There are hundreds of thousands of similar devices in the United States today attached to people's hearts. One of the biggest questions in criminal procedure law is, how will Fourth Amendment deal with the information collected and stored by all these medical devices, as well as smart home devices and all the other things we own that collect information and transmit that information to third parties? Did the police even need a warrant to get Ross Compton's pacemaker data? Was getting that information a Fourth Amendment search in the first place? This is just one of many frontier issues that are likely to arise in criminal cases over the next several years. And it's an issue that's likely to be governed under the Supreme Court's most recent major Fourth Amendment case, U.S. versus Carpenter. We're going to get into Carpenter today, which is a complicated case, but first let me quickly recap some Fourth Amendment law. This is just sort of an overview of current law from Katz to Carpenter. I'm going to start with physical searches, where the police actually touch your property or your stuff as they search for things, right? The Supreme Court has recently adopted a so-called trespass test for physical Fourth Amendment searches. Under this test, a search occurs when the government agent physically touches certain types of property for the purpose of gathering information and does so without permission. We could talk about that more, but our focus today is on cases that don't involve physical trespasses. So let's talk about non-physical searches. These make up a big portion of modern Fourth Amendment cases, and since 1967, they've been governed by the Katz test. The Katz test applies to Fourth Amendment's protections when the government has violated a person's reasonable expectation of privacy. This is a fairly vague standard, and it's one of the most criticized doctrines in all of Fourth Amendment law. Its lack of coherence has made Fourth Amendment search law notoriously confusing, although there is something to be said for a flexible standard like this. But anyway, let's talk about a common scenario in modern cases involving digital evidence. Let's say the government wanted to obtain some digital information about a suspect, and they want to get this information by requesting it from the suspect's internet provider. Before the Carpenter case, the government could probably get this information without a warrant under what's called the third-party doctrine. The third-party doctrine states that the Fourth Amendment doesn't apply to personal information disclosed to a third party and obtained by the government from that party. The Supreme Court established this doctrine in the 1970s. In Smith versus Maryland, for instance, the Supreme Court held that the Fourth Amendment didn't apply to the telephone numbers that a customer dialed, in part because customers voluntarily disclosed the numbers to the telephone company. As you might imagine, the third-party doctrine is controversial. It's especially problematic in the internet era, when a huge variety of personal data is transmitted over the internet and exposed to third parties. The third-party doctrine threatens to erode Fourth Amendment protections for emails, web surfing data, search terms, subscriber information, email address data, shared documents stored online, and more. It eventually became pretty clear that the Supreme Court was going to have to cut back on the third-party doctrine, which it hadn't applied in a Supreme Court case since 1979, before the internet age. And lo and behold, in Carpenter, the Supreme Court limited the third-party doctrine's application. It held that at least some data disclosed to third parties was still protected by the Fourth Amendment. Let's talk about the Carpenter case. First, I should tell you that your cell phone sends out signals that can be used to track your location, in case you didn't know. The FBI agents suspected Timothy Carpenter of involvement in a series of robberies in the Detroit area. They requested cell phone signal records from Carpenter's wireless providers, Metro PCS and Sprint. With this information, they could place Carpenter in the general location of several of the robberies. Carpenter sought to have the evidence suppressed, claiming that it amounted to a Fourth Amendment search performed without a warrant. The Supreme Court ruled in a 5-4 decision that the government must obtain a warrant before accessing a user's cell phone location information. Was Carpenter a big deal? The short answer is yes, but it's worth noting that the court only directly addressed one issue. They said you need to get a warrant in order to collect cell phone location data. And they said, we're not deciding any other issues not before us. We're just deciding this one. But in practice, it's obvious that Carpenter was a big deal in Fourth Amendment law. It stands for the proposition, pardon me, that the third-party doctrine will be limited in the internet age. And while it doesn't set out a test to govern similar cases going forward, it discusses several factors that drove its decision. Courts have picked up on these factors in post-Carpenter Fourth Amendment cases. Carpenter's been hugely influential in the lower courts, right? You don't have to take my word for it. Pretty much every law professor with Fourth Amendment expertise has called Carpenter a revolutionary decision. Here's just a few of them. Now, the Carpenter opinion itself was ambiguous and subject to interpretation. People have wondered whether Carpenter implicitly sets out a test for future cases, and if so, what is it? And we really need to know, what will Fourth Amendment law be going forward? Well, Carpenter didn't set out an official test to guide future decisions, but it did identify several factors that compelled it to protect cell phone location data. Here's a nice summary quote from Carpenter about cutting back on the third-party doctrine. It summarizes some of the factors that it talked about. I won't read it here, but the key point is that lower courts have found 3 of the Carpenter factors to be sort of the most important, just in terms of how often they show up in a case and how influential they are. Revealing nature, amount, and voluntary disclosure seem to be the key factors, right? Revealing nature is just the tendency of data to disclose sensitive or intimate details about a person's life. The more sensitive and intimate the data is, the more likely that collecting it will be a Fourth Amendment search. The amount of data is just the quantity of data sought by police. In some cases, this is closely related to the duration of surveillance, how long the surveillance lasts, right? The more data the police obtain, the more likely it is that a search has occurred. And then voluntary disclosure is just whether the person voluntarily turned their data over to a third party. These factors are by far the most influential and widely used in post-Carpenter cases, and they can be used as a multi-factor test for novel Fourth Amendment questions. Indeed, some courts have used them exactly this way. I've called this 3-factor test the Carpenter test. You don't necessarily need to call it that or think of it that way in order to use the factors. You can just do sort of what the courts do, which is examine these factors without necessarily calling them a test. And maybe mention that these are factors that are most widely used in post-Carpenter case law, right? Here's a case that, overtly adopts the test, for example. This was from last year. And I think more and more courts are likely to follow that path going forward. Now, briefly, how does Carpenter fit in with the old CATS test? Well, I think it can offer a way to put some meat on the bones of the CATS test. Like, we have to figure out whether someone has a reasonable expectation of privacy in some new form of data. The Carpenter test can help us with that. But I'm not saying that it's replacing or displacing the CATS test in any way, really. It's more that they exist simultaneously, so you can cite CATS and then use Carpenter to sort of flesh it out. And with that, I'll sort of pass the baton to Joel here.
Thank you. So, having getting the background on Fourth Amendment law, Carpenter, and Smith v. Maryland, and all these other fun cases in like 5 minutes, I guess. Hopefully, we can briefly talk about some of the technology issues and how it's applied. Please submit questions. We can take them at the end, or if there's anything regarding something we're saying now, we're happy to talk about right now. But let's move on. Next slide, please. So, this really interestingly comes up in the area of geofencing and geolocation. And for those not familiar, geofencing is basically the idea of creating a virtual boundary, a virtual fence around an area, and then technologically looking for all devices within that area. So if you look at this picture, and this is actually a picture I took from warrantbuilder.com, of a good site that a lot of law enforcement uses to actually generate their warrants. And you'll see that big in the middle is big red square. And you'll see there's 1, 2, 3, 4, 5 little dots. Those are the devices that were in that geofenced area, that virtual area at that given point in time. Next slide, please. So geofencing you can do geofencing or geolocation a few different ways. You can use GPS, which is probably the most common way. You can also use Bluetooth or Wi-Fi. And there's also RFID location, which is more common in factories and warehouses, etc., tracking packages as they move. Now, I say geofencing / geolocation because the technology is basically the same. However, the question is, who is using it? When you're using it for law enforcement purposes, for Fourth Amendment purposes, we generally refer to geofencing. Geolocation goes on all the time. When you walk into a store, for example, and you start seeing your phone send you ads, or there's something that shows up on the screen if you have a screen in the store relating to you. Specifically, it's because your RFID or the Bluetooth in your phone was turned on and they know you're there and they've seen what else you're interested in. They try to advertise something that's more customized to you. That's sort of geolocation. Geolocation is used for advertising, for selling, for art targeted advertising. It has a lot of legitimate commercial purposes. I will say that it has become more of a privacy sensitive question from a civil perspective as well, which is why many state privacy laws now actually require geolocation to meet up higher standards. Either it's opt-in consent or companies have to do a data privacy impact assessment and have additional protections in place for geolocation. But putting that aside, let's move to geofencing. When the government does it, and it's for Fourth Amendment purposes, criminal investigative purposes, we call it geofencing. Same idea, really. And the idea is that we have an area. You use a device. When the device crosses that area, that threshold, so to speak, it turns the physical location to a digital trigger and it goes off. Just like in the old Mission Impossible movies where you have those red lines and the laser lines, you cross the red line, it triggers something. Next slide, please. And by the way, I will tell you, the most common way you've probably seen geolocation in your lives is, and I have 4 kids, so I can tell you this because I go to McDonald's way more than I want to admit, but whenever you place an order for them and you drive close to McDonald's and it says you here, you say yes, and it now has that signal knowing you are close proximity. That's geolocation. So how does it work in the criminal context? So geofence warrants, which are also known as reverse location warrants, because you're starting from the point of a location as opposed to an individual. Now, there's no steadfast rule on this, but the general understanding and the general way it's worked, and Google being one of the biggest providers of this, is that law enforcement will make a request for data for a specific area, which generally is a crime scene, during a specific time period. And the smaller the time period, the better and more concise. They send the warrant to the company, in many cases Google, for their sensor vault, which is where they capture the location data, with coordinates, a radius, and the time window, and say, hey, can you tell us all devices that you're tracking in this fenced off virtual area at that given point in time? The company then sends back anonymized information on the devices, potentially phone numbers, maybe SIM card numbers, etc., without names or any identifying information attached to them. Law enforcement then narrows down the devices to try to figure out who might be relevant suspects. The idea being, especially if you have more than one crime scene and you do this, the same device is showing up in multiple crime scenes at the same time on those other days, lessens the amount of people who are probably going to be looped into this. Once law enforcement has narrowed down the list, they go to Google or whatever the provider is and say, can you give us the identifying information for these devices? And that's when you get the specific identifying information. And then they use that with traditional investigative techniques to try to figure out who the people are, who the targets are. Now, this is controversial for a few reasons. First of all, going back to traditional Fourth Amendment, we have to have probable cause is required for a search warrant to be issued, which means the place to be searched and the persons or things to be seized. And if you think about it, when you're doing a geofence reverse location warrant, you don't know who those people are. All you know is there are devices there. You don't know who they belong to and what the names are. So you're starting from a reverse to some extent. Not to mention, there could be hundreds or thousands of devices there, so there's not a lot of specificity there. So defense will often argue that this is not specific and it's not enough to make out probable cause. There's also critics that will say it's a fishing expedition, which you could argue because you're casting a big virtual net around the whole crime scene and looping in a lot of people, which gets the idea of unreasonable search, meaning we're sweeping up lots of data on hundreds, if not thousands, of innocent people in an area. Of course, it's different if you're in a small rural area, you probably have less people. In a city block, if you do a geofence on a building in New York City, you could probably sweep up hundreds or maybe thousands of people. And therefore, that's unreasonable, according to defense counsel and the people who don't like this, because they say it is basically, bringing in a lot of innocent people and searching many, many records when there's no probable cause to search them. Next slide, please. So there's been a number of litigation. There's been a lot of litigation about this, but there are 3 circuits who have gone to the circuit level, and there's been a split into circuits, which we'll talk about now. So one comes from my neck of the woods. I live in Maryland, right outside DC. But it was a bank robbery in Virginia back in 2019. The guy's name is Okela Chatri. And there were no witnesses that they could find that could actually identify the individual who performed the bank robbery, got into a bank safe, I believe, and stole a couple $100,000. They looked at footage. They weren't really making a lot of progress. So law enforcement then looked at the video and showed a man outside the bank before the robbery holding a cell phone. So they said, wait a minute, this person who we think might have been the suspect had a cell phone. So let's go and see if we can find out what cell phones were in the area and track backwards. That's when they got the geofence warrant, went to Google and said, give us all the devices within a 300-meter radius of the bank. So not a huge area for a 2-hour time window around the time of the robbery. They went through this process. They got all the devices. They weaned it down. And eventually, they identified a suspect, Chatry. Chatry was eventually arrested and he was prosecuted, but he moved to suppress the geofencing evidence. And his argument was basically relying on Carpenter. His argument was basically overbroad, no probable cause, as well as the fact that, this does not meet the Fourth Amendment standard because it is not fair to just start throwing a huge net, fishing, so to speak, over a large area, just rooping everybody and then hopefully find someone and you don't know if the person's actually guilty or innocent. And I will tell you, there have been other geofence cases around the country where people have been looped in and have become targets, unfortunately, when they were innocent. One of which was in Florida, for example, where a guy happened to be riding his bike by a crime scene and he ended up becoming a person of interest, even though he was just merely riding his bike and he just happened to be in the wrong place at the wrong time. Anyway, the district court, relying on Carpenter, in this case for Chatry, ruled that the government had conducted a search because they actually got all these records. They had gotten 2 hours of information, detailed records on devices, and therefore they said, because this was a search and it lacked probable cause, the warrant was unconstitutional. Interestingly, however, the evidence was not suppressed in his case because in U.S. v. Leon, which is the good faith exception, if a warrant is invalid, but evidence shows that the law enforcement officer acted in good faith, he'd had plenty of geofence warrants granted in the past, etc. He acted in good faith reliance, they're not going to suppress the evidence. So, ironically enough, the decision from the district court about saying this conducted a search, and it lacked PC, was not going to help Chatry because it was still using the evidence against him, but it did have some reverberations for future cases. Chatry then entered a guilty plea, conditional guilty plea after his motion to suppress, and he's sentenced to 141 months in prison and 3-year supervised release. But he appealed. That was the conditional guilty plea. Next slide, please. So next slide. This went up to the court. Okay, there we go. Thank you. So the district court's decision basically was unreasonable search, illegal, but we're not going to suppress the evidence. The Fourth Circuit majority basically disagreed with the district court. They said no search occurred. Why? Because it was and going back to the 3-factor test that Matthew mentioned, limited privacy implication. A 2-hour window, which is what they sought, is a very small period of time. The concept in Carpenter, by contrast, was they'd gotten records for a month worth of time for Carpenter, and therefore that was a very long period of time, and the courts argued there that you could put together a literally detailed, intimate video window of someone's life, where they go, their political affiliations, you can figure out they're having affairs, they go to the gym, you could just literally piece together very clearly. But in this case, a single trip, 2 hours, in isolation, the majority said, is no more revealing than a subpoena bank record. They also claimed, and this is the one where I take more issue with personally, that the data was voluntarily exposed to Google, and therefore there's no reasonable expectation of privacy. And the reason I take issue with this only because of a lot of the civil litigation that's gone on with Google over the past few years, where we've seen over and over again class action suits, lawsuits brought by states' attorney generals, etc., arguing that location isn't really turned off, even if you turn it off. In this court, the Fourth Circuit said, well, Chatry opted in because location is off by default. We know from other litigation and other class actions with Google recently that sometimes you could turn off one location setting someplace, but you didn't turn off 2 other places, and it's still capturing it. So it's always been a question in my mind whether you truly can opt out and you reasonably expect privacy, because are you really turning off location? Especially if you try in one setting, but you don't do it in the other setting, you don't realize that. But nonetheless, in this case, the court argued that because it was because it was optional and he turned on location information, and unlike Carpenter, with the data we were talking about is CSLI, cell site location information. Basically, the information that bounces from cell phones off of cell towers to keep your connectivity. Carpenter court said that is a vital part of modern day life, and unless you turn off your phone, you can't really participate in modern life. By contrast, Chatry, the Fourth Circuit here, said, well, that's not really the case. Location information can be turned off, nice to have, but you can turn it off, and it doesn't make you not able to participate in modern day life. So as a result of those 2 factors, they basically said this was not no search occurred. On the other hand, the dissent, interestingly, thought that Carpenter would still actually apply here, and that a search did occur because when you look at the mosaic here, I will note one more thing, and I'm going to move on because we're going to have Matthew talk about the Fitzer case. But one thing that's really interesting here, which I've always found fascinating, which is one of the underlying issues of technology here is that technologies provide an opportunity that law enforcement today that didn't exist in the past. So yes, you could actually have law enforcement sit there and surveil a house. You could sit outside a person's house and follow them for 2 or 3 or 4 days. If it's a really serious case, they might allocate resources to follow them 24/7 for a number of days. So you could put a picture together. But the one thing you could never do without technology is go backwards. You couldn't see in the past what had happened, the retrospective records. Technology's enabled that, and that's where this gets to the idea that, surveilling is one thing, but be able to go back in time basically with a time machine and see what happened and basically surveil someone before you even actually had the crime occur, for example, is controversial because the technology is the only thing that makes that possible today. On to you, Matthew.
Thank you. There we go. So I'll just briefly talk about United States versus Smith, sort of another case in this circuit split, where they split very much from Chattree. The facts are similar, but the outcome is almost the direct opposite, right? So in this case, Jamar Smith robbed a mail truck, and police used a geofence warrant to identify his cell phone as being one that was present at the time of the robbery, in the area of the robbery. The case has sort of two main holdings. The first being that Smith had a reasonable expectation of privacy in his location data. Geofences, the court said, can be revealing even in their limited time frame. As Joel was talking about, the time frame is limited. Court said, look, they can be revealing even in that time frame. And although users give Google permission to collect their data, courts said, and I quote, electronic opt-in processes are hardly informed and in many instances may not even be voluntary. The court also said that users are bombarded multiple times with requests to opt in across multiple apps. These requests typically innocuously promise app optimization rather than reveal the fact that users' locations will be comprehensively stored in a sensor vault that Google's named for its storage unit, providing Google the means to access this data and share it with the government. So the first holding is basically disagreeing with Chattree, saying there was a reasonable expectation of privacy in this historical location data, and that the Fourth Amendment applied. Then the second holding may be even more interesting or controversial, was that geofence warrants are per se unconstitutional because they're general warrants that search without probable cause, right? Typically, if something is a Fourth Amendment search, you can still get a warrant for it if you have probable cause. Here, the court was saying these are too much like general warrants, and so you can't get them even with sort of probable cause to think you'll find something. The idea was that Google's geofence search process involves searching its entire database for location coordinates that match the geofence and the time, right? They sort of that means everyone with Google location history on gets their coordinates searched by the computer, and this is like over 100 million Americans. The court felt that they're getting searched whenever there's a geofence warrant. Now, again, it's a controversial holding. It cuts pretty widely. It's controversial in part because no human being actually sees anything when a computer searches a database. It's just like control Fing through a document, right? It's a pattern match done by a computer, sort of like control F for numbers. And so this created a circuit split. The Supreme Court recently granted in it, which is making geofence warrants sort of the hot Fourth Amendment topic right now. And I think those two cases created the split. There's another case involved as well, and Joel's going to talk about that.
Yeah, just briefly, it's actually interesting. The case doesn't really help establish the law any further in terms of if it's the 11th Circuit. Bottom line, many robberies occurred over a long period of time. Montgomery, Alabama, the Montgomery Police Department, FBI got together and started investigating when 4 more robberies occurred in 2020. They got a geofence warrant. They sought it for a very small period of time, 15 to 40 minutes at each location, corresponding to video surveillance, etc. So there was a legitimate belief that it was, if you showed up in these 3 or 4 places at the same time with the same devices, you were more likely to be the person. Davis was convicted federally of multiple counts of carjacking on robbery. And they appealed, obviously, arguing the warrant lacked particularity, places to be searched and things to be seized. The 11th Circuit, interestingly, said they didn't get to the constitutionality of the geofence warrant because Davis actually didn't have standing to challenge geofence warrant. Why? Because the phone that they used to track geofencing actually belonged to his girlfriend. And going back to the third party doctrine, etc., you don't have a reasonable expectation of privacy in a device that belongs to someone else. So it happened to be his girlfriend's phone. If it's his phone, it probably would have been a different outcome in terms of at least how they handle this. And therefore, they never got to the constitutionality issue. However, in the 11th Circuit did get into the idea of distinguishing Davis from Carpenter, saying that, once again, the search reflected a very short period of time with a very small area, just a couple of 100 meters, and they were in public spaces, not in someone's home where you have an increased expectation of privacy in someone's home. And therefore, you can't put together a mosaic of a person's individual movements over a period of time. And therefore, hinting that this would not have been considered a search under the Fourth Amendment, even if they did not kick it out for lack of standing. And as Matthew mentioned, the latest is that January this year, which is last month, the U.S. Supreme Court agreed to review the constitutionality of geofence warrants. My personal opinion, which I love, is, I should say I love, which I love having my class talk about. We debate this in class, actually, for one of the sessions, basically is, how would you put together a geofence warrant potentially to make it more, palatable? And some people have argued that, for example, for each of those three stages, you have a second required to go back to the courts. You get a warrant to just get the device searches for the geofence information, a second warrant to go reveal the names and identifies the people. Others, students in my class, have actually suggested that perhaps we do this like a wiretapping thing where it's only limited to a very limited number of serious crimes when you really need the evidence and you have to exhaust all other remedies, etc. So there are discussions about how to basically make this a little more palatable and maybe more compliant with the Fourth Amendment. But the Supreme Court is going to be taking this up, and I suspect in the next year or so we will actually know the answer to that.
Yep, and we both been sort of thinking about that case. The case is Chattree. They went up to Supreme Court. So if people have questions about that during Q&A, we can talk further about that for sure because it's on our minds right now.
Professor,
Tom, are you about to give us a code?
yeah, let me break in and do the code word for CLE credit. So the code word that attendees will need to write down on their affidavit in order to submit it for CLE credit is fourth, FOURTH, fourth as in Fourth Amendment, fourth grade. What else can we think of? Fourth rate,
Fourth place. Yeah, thanks.
fourth place. Yeah.
That's what you want to hear. Fourth rate when we're doing a presentation. Yes, fourth rate.
FOURTH. It's fourth. Thanks, guys.
Thank you.
Thanks, Tom.
So I think next slide, Matthew. Yep, there we go.
Yeah, sure. So I'll talk about a case involving this technology here, which is smart utility meters. You may have this on your home as we speak. That a smart utility meter collects detailed energy uses information from users' homes. Smart meters can help promote efficient energy grid management and reduce emissions. Right? It's a good way to reduce greenhouse emissions, for example. In the Naperville Smart Meter Awareness or City of Naperville case, a public interest group sued the City of Naperville over their smart meter program. They alleged that the program violated the Fourth Amendment. The Seventh Circuit made two rulings in this case. First, they held that the smart meter data was a Fourth Amendment search under Katz and Carpenter. And second, they held that the search was reasonable under the special needs doctrine of the Fourth Amendment. Now, we don't need to worry about that second holding here today. The interesting part for us, I think, is the first holding, that this was a Fourth Amendment search in the first place. How did the court come to that ruling? Well, they basically applied the Carpenter factors that I was talking about earlier. I'll tell you what they concluded. The court determined the records were potentially quite revealing. Smart meter data reveals when people are home and when they're away. They reveal when people sleep and eat, what types of appliances they have, and when those appliances are used, right? It's that detailed. Basically, this happens because each type of appliance or plug-in item has a distinct energy signature. If you know the signature, then you know exactly what appliance or item is being used and when it's being used. So you can get a fairly detailed data going about what's happening inside of a home. The amount of data collected here was very large. Basically, smart meters collected data every 15 minutes, and they did this basically forever, for as long as people lived in their home or apartment. They stored this data for up to 3 years. So the overall amount of data collected was really huge in this case. Finally, the data wasn't really voluntarily disclosed. Every citizen of Naperville had to get a smart meter installed. You could request a disconnected meter that didn't constantly transmit data to the city. But even these meters collected the same data. It just they had to send someone out to plug into it and retrieve it. But ultimately, the same data was disclosed. So this was pretty much inescapable for the people of Naperville. To me, as a result, I think this was a fairly straightforward case under Carpenter in that all three of the sort of key factors pointed to the idea that this was a Fourth Amendment search. And I think the Seventh Circuit held correctly that under Carpenter, this was definitely a search. So I think that's one of the sort of major post-Carpenter cases out there.
And I will say the age-old question, Santa knows when you're sleeping, when you're awake, when you've been good or bad. Maybe he has a smart meter reader that's been using. So now we know the answer to the age-old question.
Could be.
So let's talk about another case here. So health wearables, we talked a little earlier about the pacemaker, but first let's talk about Mr. James Bates. Hot tub, throws a party, vodka's drunk, beer is taken in and imbibed. Eventually, and this is in 2015, by the way, so this is pre-Carpenter. Bates goes to bed. He still has friends in the jacuzzi. The next morning, he wakes up around 9:30, and they find Victor Collins floating face down in the hot tub, drowned. Some articles I've read also said that his body was cut and bruised. There may be a little blood in the water, but I've seen different accounts of that, so I'm not positive of that. But either way, clearly they believe that some foul play occurred here. 3 months later, the police arrested Bates on first-degree murder. As part of the evidence they used for the arrest warrant was that they went and got the smart meter records. So lo and behold, as Matthew just mentioned, they provide intimate view into your life. And what they did was they looked at the water usage by him between the hours of 1 to 3 a.m. And by the way, when I say by him, by someone at the home, because obviously we don't know if it was him or not. And they said it looked like someone was trying to clean up the murder scene and clean everything out and replace the water. Now, I'll argue that if this blood floating in the water is true, then he probably didn't do a very good job of cleaning it up. But nonetheless, bottom line is it's about a 1 to 2, 3 hour, 1 to 3 is a 2 hour window. So that was part of the evidence. And again, it was secured not through a search warrant, but through actually a subpoena. Because again, idea being third party, meter company, and therefore they don't need to actually get a search warrant. Eventually, the case was dropped in 2017 by prosecutors because they believed the evidence could support more than one reasonable explanation. They apparently did not have any first-hand witnesses, and the replacing of water between 1 to 3 a.m., assuming it was Bates, still doesn't necessarily mean that person did something wrong. So basically, it was never prosecuted. So we never went to trial on this, never went to a conviction. Next slide, please. Now let's revisit our old friend, Mr. Compton, our pacemaker friend, the one who basically had the fire. He was allegedly prosecuted for felony aggravated arson and insurance fraud because the pacemaker that he had in his chest did not necessarily reflect what he said he did on the day of the crime. In other words, when the fire occurred, he said he actually gathered all his belongings, he threw them out the window, he climbed through the window, he done all stuff. And within a small 15-minute window of time, no pun intended, looking at the pacemaker records, the doctor said, this doesn't look like someone doing all that. This looks like a guy who's, his heart rate is pretty steady. So the idea that he got all his stuff out and did this at the last minute as opposed to planning for arson was less likely. The defense nonetheless moved to suppress the pacemaker data because they argued even with probable cause, it was unreasonable because it was very invasive. Obviously, it's inside his body and his heart. Can't think of anything more invasive than in your house, in your body, in your heart. The trial court looked at two factors in that. They said, what is the invasiveness of the process? What's the criticality of the evidence? In this case, they said, yeah, it is a pacemaker in his heart, but the invasiveness wasn't the law enforcement going in, grabbing it, cutting him open and getting that. It was just transmitted to a computer. So it's not that invasive in gathering the data. And then with regard to the criticality of the data, it was very critical in terms of being able to make out this crime. There was being pending appeal. Excuse me. It was pending appeal when basically, unfortunately, Mr. Compton died in July 2020. So the case never proceeded fully to decision, and we do not have an answer on that question. Next slide.
There we go.
No, back one. Yeah, there we go. So let's talk about these three things we just talked about. We talked about Naperville smart meters, Matthew. We talked about Bates and Compton. Now, all of them notably are pre-Carpenter. Naperville is around the beginning of Carpenter, but still,
I think it's right after. I think it's like just after Carpenter.
All right, just after. But you didn't have a decision yet. So going back to the three factors that Matthew talked about, revealing nature, amount of data, and voluntariness. So let's look at Bates. So if there was Carpenter in 2015, again, they got the data with a subpoena, not a search warrant. Was it a search? The revealing nature, water usage, you could argue it is revealing, when the person's home, how much water they use, etc. Not so much as electricity usage, as Matthew mentioned earlier, but it was only a short period of time, a 2-hour window. So the amount of data is not very large. So going to sort of the Chattree Court, Fourth Circuit, the idea it's a very small window of time. It's not a long period of time. You can't put a mosaic of someone's life together. And therefore, it is not a very, likely to have been very invasive in terms of the amount of information. Voluntariness, there's no voluntariness there. As mentioned, the meters sort of collect it automatically. Very few options for opting out. So would a subpoena have sufficed after Carpenter? I mean, I think that's a big open question because I think the revealing nature of the water usage is only, it's not as revealing as some of the other kinds of data you get, like CSLI data. The amount of data is small, but it's not voluntary. So I think that would be an open question how this would handle today, depending on the court. Compton, our friend with the pacemaker, now they did get a search warrant. It was inside his body, so clearly very revealing nature. Extended period of time because it was capturing those records over a period of time. It's not just one moment in time. They had the records going back for a certain, for the pacemaker before, during, and after. And it's clear it's not voluntarily disclosed. As a matter of fact, his life depends upon the pacemaker being monitored. So he has to send it out, and it's not done. He can't opt out of that. So just like in Carpenter, where they said a CSLI records, cell set records can't be opted out if you want to participate in modern daily life. In this case, Compton couldn't participate in life, period, without this pacemaker being operated. So I suspect that they would certainly consider this a search. Whether or not they would overrule it and say that it was invasive or overly invasive, under the Carpenter factors, we don't know. And then you have the Napersville case, where they did say it is intimate personal details. There is a search, but given the government interest in this program and diminished privacy interests at stake, the search was reasonable. Which is interesting because in Carpenter, one of the ways, the justifications that the court discussed, the third party doctrine, which initially many, many years ago said third party has it, no expectation of privacy. They now moved around to it's a diminished expectation of privacy. So when you release it to third parties in these cases, technologically speaking, you don't lose your expectation of privacy, it's just diminished. So it's very similar to what they said in the Napersville case. Next slide.
All right. I'll talk briefly about a somewhat less straightforward case. This is a case that involves what's called automatic license plate reader cameras, right? You see a lot of cases these days involving these. These are cameras that record the license plate of every car that passes by. And what I'm showing you here are the bridges that connect the main body of Massachusetts with Cape Cod. Basically, the Barnstable, Massachusetts Police Department put a license plate reader camera on each end of these two bridges. And so there were 4 cameras in total. In a Massachusetts Supreme Court case, the police tracked McCarthy's vehicles that drove back and forth over these bridges from inland Massachusetts to Cape Cod. The travel was one piece of circumstantial evidence that McCarthy was transporting drugs to Cape Cod. The police had lots of other evidence as well. But tracking McCarthy helped the police build a case against him, and it alerted them when he was in Barnstable with drugs. They eventually arrested him and found heroin on him. Ultimately, the Massachusetts Supreme Court held that the use of the license plate reader cameras was not a Fourth Amendment search. Their opinion's a little long and sort of meandering, but basically they look at several of the Carpenter factors in it, and I'll run through them briefly here. The court explains that license plate camera surveillance here wasn't really revealing. All it disclosed was one particular trip over a bridge. He only ever used one of the 2 bridges. And even in the abstract, video surveillance of cars in only 2 locations isn't especially revealing of people's lives and activities, particularly since these locations weren't a home or a place of worship or etc. Instead, they were busy bridges, the gateways to a tourist destination. In other words, the location tracking here was a lot less revealing than the tracking in Carpenter. Likewise, the court concluded that the amount of surveillance wasn't especially large, although it also wasn't nothing. The surveillance lasted for 3 months, and it captured a large number of trips across the Sagamore Bridge. And the court noted that this license plate travel data was stored for up to 1 year. But again, it was only 2 locations, and so the potential for voluminous storage of data about a person's activities was pretty limited. Finally, there was the issue of voluntary disclosure, and this one was a little tricky. On the one hand, these were public trips on public roads, and so we might say, look, this car had exposed its location for anyone to see and record. The court rejected that, and I think it was right to do so. After Carpenter, we're looking for voluntary disclosure of information, and people don't really have a choice except to travel in public sometimes. Carpenter stands for the proposition that people have a Fourth Amendment right against complete surveillance of their physical movements in the outside world. And part of that idea is that sometimes what you do in public isn't really voluntarily disclosed to anyone. So yeah, there wasn't really any voluntary disclosure in this case. McCarthy didn't actually give his data to anyone, and he probably didn't know that the state was tracking his license plate when he made these trips. But the other 2 Carpenter factors point towards the idea that this was not a search, and the court, I think, correctly concluded that this was not a search. The data wasn't very revealing of McCarthy's life, and there wasn't very much of it. So no search there. I'll pass it back to you, Joel, for vehicle telematics.
This is one of my favorite little pet projects here, vehicle telematics. And only because I got involved in this a number of years ago when I was looking at a case dealing with airbags and when police can get information from a car after an accident, accident involving death, to look at the airbags. So it is not going to be a surprise to some of you, maybe a surprise to others of you, that our vehicles are massive computers today collecting lots and lots of information. But it's not just the automakers themselves. There are monitors, seatbelts, the engine temperature, airbags, braking, etc. But there's also the original equipment manufacturers, OEMs, and third-party software installed there for sensors, potentially thousands of data points. You'll see the picture at the bottom of all the different ECU sensors, electronic control units. But then, you have a infotainment system. That's one provider. You have maybe Sirius satellite radio, another provider. Maybe someone who provides the maps, another provider. Someone who provides real-time traffic data. Someone who provides parking data. You can have many, many, many third parties getting access to this data. And, car companies, historically, good at making cars, some better than others, but they're not good at dealing with lots of data. So over time, these vehicle data hubs have evolved to ingest all this data, all this information, and basically put it together, sell it, package it. It's used for everything from selling to insurance companies to help set insurance rights, but also for legitimate purposes as well. I mean, insurance is not illegitimate, but I'm just saying for reasons that have nothing to do with individuals, such as electrical vehicle infrastructure planning for the roads, fleet management, location intelligence in case something breaks down, etc. So there's a lot of good uses for this, but the challenge is that there's a lot of data generated, which now creates some questions about Fourth Amendment when criminal law enforcement wants to get a hold of it. Next slide, please.
Oops.
So
there we go.
that was a trick. So I have a couple of companies here just to show you these data hubs. Ulysses Group, which I believe is still around, and this is a document obtained by Motherboard, an online publication to focus on technology. You see Ulysses Group, it was apparently a memo. It said they have real-time data. They develop patterns of life, identify networks and relationships, and they can access over 15 billion vehicle location around the world every month. So going to the idea of like a pattern of life, a mosaic, if you can get that much data and that many data points for a long period of time, obviously that can be very, very invasive. Autonomo, actually, interestingly, is no longer around. They were purchased by a private company and taken private, but they too, had a huge data set. They said they were a vehicle data platform marketplace. They had 16 OEM fleets and more than 100 service providers sending them data, over 4 billion data points per day. And as we've seen in some of the expose articles in Washington Post, New York Times, when you have a lot of data points and location, you put them together, you can easily put together a person's pattern of life. And indeed, even without knowing who the person is, some of the papers have shown you they can actually figure out who the individual is based upon where they went. So this is really big, a lot of data. Next slide. So how does this come up? And by the way, going back to the idea of Carpenter, so the argument is that, number one, we get consent. When we sell you the vehicle, you consent to allow us to track all this information. I pose this question. It's a rhetorical question because I don't recall seeing ever being asked to sign a terms of service for each and every one of the OEM systems in my car. And other than maybe saying I don't want to use Sirius after the 30-day trial period expires, I don't recall anybody ever giving me a privacy policy and notice and what I can do to opt in or opt out. I don't recall seeing opt-out instructions. There is actually a service online for those interested. It is actually called Vehicle. I'll have to look this up while you talk, Matthew. But basically, it's a service that basically is a non-for-profit, basically puts you in touch with all the different manufacturers of cars to opt out of whatever data you can. Companies also claim data aggregation and data blurring. But the challenge, again, as I mentioned, is when you have GPS coordinates over a period of time, you frequently visited places, you can eventually figure out identity. And the smaller the area, the more easy it is to figure out identity. So next slide, please. So let's talk about when this was used actually in practice. Some people may remember our attorney, South Carolina attorney, Alex Murdaugh. He was convicted of murdering his wife and son at the barns, I think, where they had horse barns. And one of the pieces of evidence that was used was information from his GM Suburban OnStar data. And allegedly it was done by subpoena. I couldn't find the actual legal process, but according to defense counsel, they got it through subpoena. So again, not a search warrant. And what they did was the record showed that time he was at his home. They showed the time that he left his house. He left the barns, what speed he was driving at, 42 miles an hour, that his car passed by the exact spot where his wife's cell phone was recovered the next day, supposedly thrown out the window. And then after passing that spot, it sped up and went to his mother's house. Just placed him at the scene of the location of the crime, as well as dumping the phone within 1 minute after the phone was actually known to have last been handled before it was gone. So think about the factors, the Carpenter factors, revealing nature. He's on a public highway, so you could argue it's not very revealing. It was only a short period of time. Amount of data is only a few hours. But the voluntariness, again, once again, do you even know they're collecting it and are you collecting it? So whether a subpoena or, sorry, whether a search warrant would have been necessary or should have been used under Carpenter, it's hard to say. But I do think, you could argue one with the other, and it's not a clear-cut case here. Next slide, please.
All right, great. We'll just sum up briefly. I'd say there's an emerging Carpenter test that involves the revealing nature of data, the amount of data captured, and whether the data at issue was voluntarily disclosed. We can see how these factors work in some interesting frontier cases, many of which expressly apply these Carpenter factors. And, this is still a vague and developing area of law, and courts aren't especially consistent about how they resolve these cases. Plus, the Supreme Court will weigh in Chatry and may modify things. But I think this gives you a good overview of where we're at in terms of frontier Fourth Amendment issues. With that, I think we should take some questions.
Yep. And if you want to just put the slide up maybe with the toilet, the smart toilet, so people want to ask about that or you want to get into it. So there are, yes. So the slide deck you'll see there are some legislation pieces pending as well. But anyway, here's smart toilets. Open to questions.
Here, I'm going to take this. I'm going to take the slide down there for a sec. But yes. All right. Tom, do you want to keep the queue?
Sure, there's actually no questions being
Okay.
asked. I think people are stunned by all of the information and depth that you've been able to provide. This was a really enlightening talk. Thank you. Thank you both.
Great.
But
So
yeah,
can we go to the toilets?
we
Let's go to the
welcome
toilets then.
yeah, go for it, and I'll keep monitoring the Q&A.
All right. If you could put the slide back up, Matthew.
Yeah. We
So
encourage your
this is
questions, but
something that's been around for a few years now, and I've seen this a few different times. Um, Smart toilets, for sure, not going to surprise people, but the idea behind smart toilets, and I've seen smart toilets, there's also a device you put in a toilet. It's just like those colonoscopy type kits that you have nowadays. The idea being that people's waste product when they go to the bathroom can have indication of diseases, precursors to cancer, etc. So there's a lot of valuable information you can learn, as well as your gastroenterologist can learn more about your health of your gut health, etc. So there are some legitimate uses to this. But the question becomes, what happens to this data? Because once again, going to this whole idea about the Fourth Amendment, first of all, I'll ask Matthew this. My thoughts, what are your thoughts? I mean, you are literally going to the bathroom. So, when you throw away garbage in the street, you have a lower expectation of privacy, anything. You're going to the bathroom. Do you have an expectation of privacy in whatever you're releasing in the bathroom? First of all.
it's a good. I hadn't thought of that angle. Yeah, if it's like literally, a device that's capturing information from my toilet, that feels really revealing, really intimate, about as intimate as it can possibly get. But I suppose there's an abandonment issue on the feces, right? But
Yep.
I don't think it would be considered abandoned because ultimately we're not talking about the crap here. We're talking about the
Yeah.
information that they glean from it, which I think would be protected. If the government somehow wants to go into the sewer or something and try to, and then that might be
Yeah.
considered abandoned under California versus Greenwood is the trash
Yeah.
case. I like
Fair
that.
enough.
I hadn't thought of that
Fair
one.
enough. But there is actually the other angle, which is at your home, it's one thing, right? You expect you put it there. Some people do it because they want to monitor for sickness and disease, etc. But what if it's in an office setting? What if it's a company, basically? And, employers can use that to figure out, has somebody, been drinking because there's alcohol in the urine? Or is someone pregnant where you're not supposed to have to tell the employer, but now they can notice this? And also under Fourth Amendment law, you have a lower expectation of privacy in the facilities in your employment, and employers can sometimes consent to searches on behalf of the employee. So if it's in the public bathrooms, like you have smart toilets which reserve water, and employers are using this and law enforcement wants to get hold of it, it's an open question in my mind whether or not there's a Fourth Amendment protection, how far that goes, and whether or not Carpenter would prevent this from being secured or not. And, is it even abandonment in the corporate setting, not to mention consent?
That's interesting too. I mean, so I think this is where it'd be a frontier case, right? It's a workplace case, so you are disclosing it, I suppose. But I think the Carpenter factors are helpful here. I can't think of anything less voluntary than having to go to the bathroom occasionally when you work. That's why they have bathrooms in offices like that. You don't have a choice. And again, I can't think of anything more revealing. So between those two things, I would guess that a court getting an issue like that would say, look, you need a warrant to, yeah, I know this person works at whatever company and and you search the company, not the person. But I think under Carpenter, the person themselves would have a right in this. Like, I just, I can't imagine the court saying like this sensitive medical data wouldn't be protected, that just because you're at work when your company gets it or something like that.
Yep, absolutely.
We have a couple of
Go ahead.
questions, and just a couple minutes left. So one of them, Joel, is a request for the link that you mentioned
Yeah.
earlier with opting out. You can, if you
So,
can find
so the
that.
website's called Privacy for, as in the number four cars, Privacy for and cars, and basically they have connections to many of the different auto dealerships and not auto dealerships, auto manufacturers, and they tell you what kind of data these different vehicles collect and how you might be able to opt out and make requests. So Privacy for cars. I will be honest, I talked about this on the Fox 5. I do the morning TV news here once in a while about 6 months ago, and I still have this on my desk because I have not gotten around to opting out. So I myself are very poor in this, but you should do it.
Uh, that's funny. I have stuff to say about that, right? It's tough to like place the burden on consumers to opt out themselves because there's just so much to do and so much to learn and whatever. That's a good example, right? It's just like it's too much of a burden on busy people sometimes. But I wanted to take one of these questions just briefly. What are the implications for Fourth Amendment law for the ability of law enforcement to simply purchase much of this kind of data, including geolocation data from brokers? It's a great question. In the limited time I have left, I like so I have an article that I wrote about this that I like to think is the leading article on this, called "Government Purchases of Private Data." So I'll direct you to that. But basically, I argue that if something is protected, if we think something's protected out there in the world, and the government buys it, I don't think there's anything special about purchasing it that makes it not a Fourth Amendment search. So I think if the government's purchasing Carpenter protected location data, which it has post Carpenter, in order to try to get around Carpenter, I think that's a Fourth Amendment search too. And I argue that in the paper, Government Purchases of Private Data. It's in the Wake Forest Law Review, easy to Google. But yeah, so that's sort of a frontier issue. It's one that doesn't get litigated a lot, because the police sort of and these companies intentionally try to keep it out of courts. But
Yep.
it's a huge deal issue, for a variety of reasons today.
And if I could just add to that, the slide deck that I think you'll get after, you'll see one of the slides which we didn't get to is that there was legislation proposed by Senator Ron Wyden and a number of other senators about 3 or 4 times over the past number of years called the Fourth Amendment is Not for Sale Act. The idea being that they don't want to allow law enforcement to go around the Fourth Amendment by purchasing this information from data brokers. So to the extent you need a search warrant in real world for getting this data from the third party, they'll go the same process theoretically to get the data from a data broker, so they can't circumvent it. Now, this has gone up a number of times. I think it passed the House in 2024. Unfortunately, 2025, it never went anywhere. So it's still, I don't know where it is right now, but it never passed as a law. But I will say that there was opposition as well. The White House, for example, was opposed to it, as well as the Fraternal Order of Police. They're saying, you put us at a handicap because this data is available from data brokers for every criminal out there. So you're going to let them get it easily by buying it, but you're going to make us go through some probable cause and figure out how to get this data. So you're handicapping law enforcement. There's arguments both ways.
Joel, I've tried to buy this data myself and I've never been able to find it. They always say like, oh, it's publicly available. If anyone can find a place for me to purchase location data on, say, some high end judges or whatever, let me know because I'll purchase it. But I haven't been able to get it.
All right.
All right,
That's what
guys.
Dark Web's for.
We
Go
have
ahead, Tom. Do
crossed.
you have any more questions?
Yeah, we have crossed the top of the hour, so there may be one or two. I did see an attendee with a raised hand, which if you all can stay on, I'd be happy to allow him to come on and speak. But before I do that, I know that folks have to get to their next meetings in a lot of cases, so I just want to do our formal wrap up and thank you both very much for this really enlightening session. Great deal of information in here. Thank you, Matthew, for being a guest and coming together with Albany Law on this. Thank you for to the attendees for spending an hour of your time with us. And don't forget that you have 24 hours to submit that affidavit with the code word in order to receive your CLE credit. Please also spend just a moment and submit the evaluation form that was emailed to you as well by Lisa Rivage. That helps us inform decisions on future topics. So thank you, everybody. Enjoy the rest of your day.